Hello creatives, I'm Joanna Penn from thecreativepenn.com and today I'm here with Kathryn Goldman. Hi Kathryn.
Hi Joanna, how are you today?
I'm great. It's lovely to have you back on the show. Just a little introduction. Kathryn is an intellectual property attorney who protects writers, artists, filmmakers and businesses from having their work and art ripped off, which is awesome. And today we're talking about content protection for creative professionals. So I've had we've talked before on the show, and I've had Helen Sedgwick and some other people, but I want to go back to basics. Just to start off with, what is intellectual property anyway, and what are some of the different rights that authors should be aware of?
Well, intellectual property is an intangible concept. It's intangible property. So if you think about a painting, and an artist paints a painting, the painting itself is physical property, but the idea that it's is expressed in that painting is the intangible intellectual property. It's the same with a book. You write a book and you have it printed, and I buy it at the bookstore, and that physical book is personal property. But the ideas that you have expressed in the book are the intellectual property, and that's owned by you as the writer, even though I own the physical book. So it's a concept of ownership for intangible property. Now, when we talk about the rights that come with that intangible property, it's really a bundle of rights. They're a group of rights. There's the right to make copies of your work. There's the right to distribute your work. There's the right to perform your work. So in the case of authors, a performance would be a play on stage or in a film. So that becomes a right that you as the author control. Copying, distribution, and performance. And so those are the things that when you go to sell your rights, those are the different rights that you think about selling.
Okay, but even further than that, when an author might, and we'll come back to licensing versus selling in a minute, but there are the rights can go even further down, can't they? So, for example, an author might only, like J.K. Rowling, owns her ebook rights to Harry Potter, whereas the print rights are held by the publisher that she signed with originally. So, which one do they fit under?
That's the right to copy.
Oh, okay.
Okay, so you can copy in a digital format, or you can copy in a print format, or you can copy in an audio format, okay? So that's all under the right to copy. So yes, the right to copy breaks down into those different formats. It would break down into different languages. It could break down into different distribution channels. It could break down into different countries. So each of those rights can be sliced and diced. And you can license or sell just a portion of that right to copy. And the same with performance rights. You could sell your performance rights to Netflix, who could do an original series, or you could sell it to Disney, who could do a film, and those are different rights. Now, Netflix might want exclusive rights, or Disney would probably want exclusive rights, but you can theoretically divide up those rights.
Fantastic. And this is so important, and something that most authors don't seem to understand, that there's this bundle of rights. And, you know, if they sign a contract, they can sign everything away, which we'll come back to. But I want to talk about selling versus licensing, because many authors just think, oh, I'm going to write a book and I'm going to sell it to a publisher and I'm going to make $1 million and life is amazing. So what's the difference between selling and licensing, and what should authors be aware of there?
If you are selling your rights to a publisher, then all of those rights that I just described, the right to copy, the right to distribute, and the right to perform, the publisher is buying them and has complete control over them, and you no longer own them. You have transferred your rights away. Not a recommended course of action. And not very common anymore. So licensing is when you define the one right that you want that publisher to have. And so if you're working with a publisher who has an area of expertise in your genre, in the English language, in ebooks. Okay, well, you can license them, just that limited right that they have the opportunity to exploit on your behalf. And then you come to a business negotiation about what the percentage is going to be that they pay you back once they exploit that right. But it's a very narrow licensing or permission, and you've reserved everything else for other publishers or other entities who might have expertise in a different area. So what you want to think about as an author, and when you're presented with a publishing contract, and the publishers try to scoop up as many of these rights as they can, whether they have an intention to exploit them on your behalf or whether they have the expertise to exploit them on your behalf. So you really have to dig in and understand who your partner is going to be, who your publishing partner is going to be, and negotiate to give them only the rights that they are most likely to be successful with, and reserve the rest for another opportunity.
Yeah, and those that license can even be for a number of years, can't it? So with ACX, it's like 7 years for audio. I did a German deal for 3 years. So is that becoming more common, that sort of number of years?
Yes. What's becoming more common is that authors are becoming more educated about their rights and what they can and cannot do. And they are starting to define the boundaries themselves. They're not just taking a contract and accepting it because, oh my God, it's so exciting, it's my first contract. They're looking at it critically. They're thinking about it in terms of their overall career trajectory. And so they are starting to negotiate those rights with limits, term limits, yearly limits, 3 years, 5 years, and then the rights come back to them. They revert back to them, and they can give it to somebody else. That encourages the publisher who has the limited right for that amount of time to do the best they can so that when the renewal comes up, they get that renewal and the author won't take that right someplace else.
Yeah, and it was funny because when I was preparing, it came up in the news, was about, especially in the music industry, people signing contracts early on. Well, there was one with Carrie Fisher who signed a contract with Star Wars where she signed away the rights to her image. And then the Rolling Stones, I read, don't own the rights to Satisfaction and some of their biggest songs. And Michael Jackson's estate owned the Beatles backlist. So, right. Yeah. And so I wonder if you could maybe comment on, like, or some other examples of sort of signing away these things can have a massive impact, on a future career. Even if you think you're nobody now, who knows where you could be?
Well, that's exactly right. And that happens, well, in the music industry, that was very typical back in the 50s and 60s. In the film industry, I mean, you think about the Three Stooges, okay? They owned nothing. They got paid for their performance, and that was it. They had no residual royalties. So that was purely a matter of poor contract negotiation, not understanding their rights, maybe not being properly represented. And which brings up the issue of an agent as well. So when you work with an agent, you can control what it is an agent has the right to license on your behalf as well. So if you have an agent who is specializes in print relationships, as opposed to an agent who specializes in relationships with Hollywood, you can divide that up as well. But it's a matter of understanding that you own everything until you slice it off. And what happened in those examples is they gave everything away.
Yeah, and I want people to really think about that, because, a lot of these bands and authors and a lot of things happen later on in your career. Like, they don't necessarily happen at the beginning. So unless you protect these things early on and take it seriously early on, you can end up in a difficult situation. But I wanted, let's move on to an interesting thing that I've seen recently, which is Enid Blyton, the children's author, beloved children's author. In Britain, this Christmas, there were all these parody books, like 5 Go to Brexit Island, using the famous 5 branding, Enid Blyton's signature, which turned out to be a trademark. So what is the difference between copyright and a trademark, and how was that publisher able to do that example of Enid Blyton's book?
Well, that was very interesting when you first raised that with me. So the difference between a copyright and a trademark is copyright protects the expression of a creative idea, okay? Trademark identifies the source of goods and services, okay? So that's the difference. With copyright, once you fix your idea in a tangible medium of expression, those are the magic words.
Yeah.
When you write it down, when you type it, when you film it, whenever you fix it in a tangible medium, protection attaches, okay? We'll talk about enforceability later, but the protection attaches. Trademark, in order to have protection, you have to be using the trademark as a trademark to identify goods and services. So what I think happened in the case of your beloved children's author is her family registered the trademark on her name and on her signature. And they did it in the United States as well. And then they sold the trademark. Now, this was not a license. This was a sale of the trademark according to the records in the United States Trademark Office. So I think that's probably consistent with what might have happened in England as well. So this publisher now owns her signature trademark for a very specific class of goods. And I'm going to read from my other screen here. For printed matter, namely a series of books, magazines, journals, newsletters, all in the field of children's entertainment.
Ooh.
Isn't that interesting?
That doesn't sound like that it came under that.
No, it doesn't. It doesn't sound like that at all. So this trademark was originally registered in 1990s sometime, okay? Now, just because that's when it was registered doesn't mean it didn't pre-exist, because that was her signature. That was her trademark. That was her brand. So it existed even though it wasn't registered. But the registration is much more narrow than how the publisher is using it now.
Wow.
Which I find very interesting.
That is really fascinating. And of course, parody itself, well, just talk a little bit about parody, because especially with what's going on in American politics right now, there's a lot of parody stuff going on that some people could take offense to. And we're not getting political, but we're just kind of talking. Could those Enid Blyton books, well, they are parody books. Does that mean they're protected in a different way?
Yes, that parody provides a level of protection. Parody and satire provide a level of protection from a claim of infringement. So it's unclear whether the copyright still exists in the books that she wrote. Under U.S. law, it probably does still survive. So if the family were to object to, and I haven't seen these new books.
Yeah. This is just opinion. Yeah, opinion.
Yeah, right. But if the family were to object to it and claim that they constituted an infringement and hadn't given permission to the publisher, then it's probable that the publisher would have a parody defense or a satire defense to infringement.
Yeah, no, I find all that, it's so interesting. This is what I love about this stuff. And I guess, you know, you and I talked a couple of years ago originally, and I've interviewed other people, but when the penny drops on this type of stuff, you know, like literally I saw those books in the bookstore and I went, how are they doing that? And was like delving into the IP rights, and it was very, very cool. So just while we're talking about names, what about using a pseudonym? Because a lot of writers listening will use a pseudonym. I mean, I use two names. So I have Joanna Penn, JF Penn. I'm starting another brand this year, which is not associated with me in any way. So how does a pseudonym affect copyright, and how do we make sure that we own it, but also, you know, we're not, if people want to keep secret, how does that work?
Okay, so a pseudonym does not negatively impact copyright at all. You are still the copyright owner, even though you are using a pen name. And the best proof that you are the pen name is the holding the registration certificate in your hand. Okay, so that is how you prove that you are the pen name. So there are ways to register a copyright under a pen name and still identify yourself in the copyright registration in the application. But there are also ways to register a copyright using a pseudonym and not reveal your true identity at all. And that is accepted by the copyright. And I do have a post on my site, which is charmcitylegal.com, that takes you step by step how to go through that registration process without ever revealing who you are and still preserving all your copyrights. And that level of privacy is important to a lot of authors, a lot of individuals who, for some reason or other, aren't interested in having people know that they wrote that particular book, but they want to maintain their rights and protect their rights in that book. So it can be done with the U.S. Copyright Office, and using a pen name or a pseudonym doesn't have any negative impact at all.
Oh no, that's great, and I'll link to that in the show notes so people can find that, because I know, especially with erotica, you know, a lot of people want to protect their names, so that's great. So you talked there. So you've said earlier, you said that once the idea is in a tangible medium of expression, it is protected. But then you've also talked about registration. So and there's also this myth. I heard it from the British Library, which shocked me recently, that if you mail mail your manuscript to yourself through the post, that this is a way to protect your copyright. And I just found that crazy, that in this day and age, because there just must be better ways than mailing yourself. So how do we protect, like, is it necessary to register copyright? What are the good reasons to do that? And is that a myth?
Is it a myth? I mean, I don't know. It might work. But I mean, ultimately, how do you prove what's in the envelope that you've mailed to yourself? And the only way to prove it is by opening the envelope. And so when do you open the envelope? Do you have to wait until you're
in court?
Exactly. Rip it open. See, this was me. So, from that standpoint of useful evidence, I think it's of limited usefulness. So registration is the best way to prove ownership of a copyright. Just flat out, it is the best way to prove ownership of a copyright. As we talked about last time I was on your show, it also gives you something tangible to leave in your estate. Okay, if it's generating multiple revenue streams, that registration is something tangible that is referred to in contracts. And so that's another reason to have it. A third reason to have it is that it provides you with an enforcement mechanism that you wouldn't otherwise have if you didn't have the registration. And the enforcement mechanism in the United States is you can file a federal lawsuit in the event of true infringement, and we're going to talk a little bit about fake infringement. And it allows you to recover statutory damages of up to $150,000 for a willful infringement. And it also entitles you to recovery of attorney's fees, which can sometimes be the biggest hurdle in bringing litigation. I don't like to emphasize the usefulness of a registration for purposes of litigation as much as I like to talk about building your body of work, building your portfolio, and having copyright applications be a regular part of your workflow. Because going back to what we said earlier, you never know what's going to hit. You never know whether your very first work is going to be the one that you're known for and the one that makes you money year after year after year. So if you've built this registration process into your workflow, you're building a portfolio, you're going to be able to develop those revenue streams. And then finally, when you do get offers from publishers or filmmakers or TV studios or in department stores to license something, you have proof that you're the owner. They're going to require that for the contract. So that's another reason to do it.
Yeah, that's great. And just on that, because I've registered my books, and when you register, you pay for a certain number of years. So there are some people who say, well, just get 5 years and then there's no need to continue paying because you are, you've proved that's when you registered the copyright, so it doesn't change, versus you should always keep them up to date. What's your feeling?
Okay, well, first of all, the registration scheme in the United States is different from the registration scheme in the UK. All right, so if you sell your books in the United States, you are able to register in the United States for one fee. You're done. $35, and you've got protection for the life of the copyright.
Wow. Okay. Right. Stop there, because that's ridiculously cheap compared to Britain.
Yeah. What are you paying?
It's about, I think it's £65 per book for 5 years, which is about $100 for 5 years. And then you have to pay more. So if I register my books in the US, that still covers me in the UK, right?
That's correct.
Well, there you go. You just saved me loads of money. Thank you, Kathryn.
You're welcome. You're welcome.
Just for everyone else who's not in the US or the UK, if they register in the US, does that cover all countries that signed? What's that law? That's
the Berne Convention. Yes, yes. And so, if you have a registration in the United States and your country is a signatory to the Berne Convention, then you're entitled to the protections that that country offers based on the U.S. registration. That's kind of how it works in a nutshell.
Awesome. That's so cool.
Yeah.
There we go. We can stop now. I've got everything I need. No, that's fantastic. Okay, so some other more like specific questions. Some people who have a company or an LLC or, and I know some authors have been told to register the copyright in the name of their own company, or should it be the author name and then you basically license your own rights to your own company?
Okay, so you need to take a look at what the business purposes are behind either arrangement, okay? I start with the premise that the author should keep the copyrights in her own name and license to her company. That's my general preference. And the reason is because you don't know where you're going to take that company. Let's say, for example, that you are the sole owner of the company and that you decide that you want to bring on a partner. And all of a sudden, the copyrights are owned by the company, and now you're bringing on a partner, and now your partner owns part of your copyrights. Mm-hmm. Is that something that you really want to have happen? So you need to think about that. Another example, let's say that your company is a small press. And when you start out, your small press is just printing or publishing your own work. Oh, it makes sense. Let's put the copyrights in the small press, etc. But what if you start publishing the work of other authors? What if your small press starts to gain traction and you want to either take on investors or sell it or bring in partners? All of a sudden, your copyrights are owned by that company, and the other authors' books are just licensed to the company. Okay? So my preference is to keep the copyrights with the authors and to license to the company, even if at this time you're the only owner of the company. Now, there are reasons for doing it the other way. And one of those reasons is if you are trying to protect your personal assets for some reason. That's not an area of the law that I specialize in, but I do know that that is one mechanism for protecting copyrights as assets is to put them into an LLC.
Yeah, that's really great. And so much of this stuff is actually thinking longer term, because there are people listening who might be working on their first book and they just can't even fathom starting their own LLC, let alone doing this type of stuff. But what I want people to think about is like 5 years time, 10 years time, 20 years time, like we discussed with Enid Blyton, that's after her death. So this is why this business is so exciting, right? Because we can do so many things if we just take ownership and realize this. So I hope people are really listening. So I have a couple more questions on this. So what about respecting other people's copyright? Because authors, I think, often see, they're like, oh, this is my copyright, and then they use somebody's picture on their blog, or they just, stick some lyrics in a book, or, what are the things that authors particularly should watch out for with other people's right?
Okay, so the lyrics are an important issue. A lot of writers want to include lyrics in their work because the song just completely embodies the theme or the message, or they use a lyric as the chapter title or whatever. So lyrics generally, you need permission in order to use the lyrics from someone's song. So copyright infringement is when you take the heart and soul of someone else's work and you put it in your own work. Now, the case law has said that when you use lyrics, because songs are so short that using even a single line, a single lyric, is considered the heart and soul of that work and therefore would be considered infringement. So lyrics you need permission for. Quotes you don't necessarily need permission for because you cannot copyright a short title or a slogan, and quotes could be considered slogans. So they're not protected by copyright. They might be protected by trademark, but they're not protected by copyright. So quotes are going to be more or less fair game. What was the other?
Like photos.
Photos. Well, you have to be careful with photos. You can't just do a Google search and find, a Google image search and find a great photo and pop it on your blog. You have to go and license it. You can use a Creative Commons license, many of which allow commercial use with attribution. There are a lot of sites out there that I'm sure you've linked to in the past. Yeah. So you have to get permission for using an image. I did a post right before Christmas on Rudolph the Red-Nosed Reindeer, which is actually a great story because the author of Rudolph, I don't know, is he big in England also?
Yeah.
Okay. So the author was an employee of a department store back in the 30s, and so the department store owned the copyright. And as a gift, the department store gave the copyright back to the employee. Right. So that's an example of what we were talking about in terms of who owns the work. But when I did my blog post, I wanted to use a photo of a local Christmas deer puppet set from Baltimore, which is where I'm from. And I found one online, and I wrote the woman whose photo it was, and I said, I'm writing this blog post. Can I use your photo? And she said, sure. I mean, so sometimes that's all it takes. It's just permission.
No, that's really good. And then, so, just coming down to some of the other things that authors are doing, many of us, well, most of us are commissioning our own book covers. So we are working with book cover designers and other people that we'll do work for hire with. But how do we make sure we protect ourselves? So we've engaged a cover designer. Many authors won't have contracts in place with these designers. How do we protect ourselves there? Like, should we have a contract and what should that say?
Okay. The answer is yes, you should have a contract. And the contract, if the book cover designer will give it to you, should transfer ownership in the book cover design to you. So work for hire contract, transfer of the entire copyright to you as the author. Otherwise, it is owned by the cover designer. And that cover designer can use the same design on somebody else's book. So, first of all, get it transferred. Secondly, you want to make sure that whoever has designed the cover has the rights to use the images that they are incorporating into the cover. And so in that contract, you want them to represent that they have those rights. All right. So in case it turns out they don't have the rights and you end up getting sued for infringing somebody's image, you get to turn around and go back to the cover designer who then has to defend you for that. So they have to say, I own the rights and I have the right to use it and to use it for you. Now, if they're using stock photos, you have to make sure that the stock license or the cover designer has to make sure that the stock license permits the use that is intended. Is it just going to be a Kindle book? Is it going to be a print book? what are we talking about? So you want to make sure that all of those are called warranties, are in place in the contract, and that the design is assigned to you. If it doesn't get assigned to you, you may not be able to use it in promotional materials. You may not be able to use it when it's time to bring out the audiobook. Unless you own it, you're limited in how you can use it.
Yeah, and again, I know a lot of people listening will be like, I haven't done that. So everyone calm down. None of this stuff is, it can't be fixed. So the point is for everyone listening to think about, okay, well, what have I got in place? What haven't I got in place? And what do I need to get in place in order to kind of future-proof, right? Because it's likely that nothing's going to happen if you're selling 100 books a month or something. But what if, as we've said, something takes off and then, suddenly you're having to deal with the cover image has something on that was never allowed.
This is another point on cover images. Let's say you're being published by, publisher A, and there's a beautiful cover on your book. And then for some reason, your rights revert and you go over to publisher B, and publisher B wants to reissue this book. Well, guess what? You don't own that cover. So that gorgeous cover is owned by the original publisher. Okay, so that's something that you have to think about. That is an independent piece of art that has its own rights. And if you want it, you have to get them. You have to get them.
No, fantastic. So much to do. Okay, so we're running out of time, but let's just talk about the how to monitor your copyright and what to do if there is an infringement.
Okay, monitoring. The easiest way is to set up a Google alert on your name, and to also I talk about the heart and soul of your work. And if you can take a line of your work that is unique and set up a Google alert on that sentence that is found in the heart and soul of your work, then when that line appears anywhere on the internet, and after Google's bots have crawled the internet, they'll send you an email saying it appears over here, and then you can go and check it out and see if that's an infringement, or if that's actually, maybe it's a review of your work and not an infringement, in which case it would be considered fair use to have that quote in a review. But that's one way to monitor your work. Another way to monitor your work is not active, it's more passive. Your fans will tell you when they see something else out there that they thought was you and turns out not to be you. And so you have to listen to your fans. You have to read those emails, and you have to follow up on that. I've had a number of artists and writers come to me saying, my piece was seen in a gift shop in, the middle of Virginia. I did not send any of my pieces down to Virginia to get sold. So, you have to follow up on that.
Yeah, no, that's fantastic. And in terms of, I would say right now, most of us are being infringed in some way by these pirate sites and torrent sites. And, as soon as you publish a book, it's pirated. And mostly, I would say, just don't worry about it because it happens to everyone. And, these sites will just continue doing it. What are your thoughts on that?
Well, initially, I'm very skeptical that they're actually pirating your book. I think that in many cases they're malware sites or they're phishing sites.
Okay.
And they, some of them are membership sites, and join here, give me your credit card, and you can read unlimited books, right? And whether the books are really there or not, I don't know, because I've never given them my credit card. So that's item number one. Item number two is if people are actually getting free downloads from these pirate sites, these individuals aren't going to be your customers anyway. And so I'm with you on the let's not worry about these pirate sites. There's very, very little that we can do about it. You can issue takedown notices, but that's the head of the Hydra, they pop back up again. One little trick that I heard about is that before you publish on Kindle or wherever it is you're going, whatever platform you're going to use, you create a false file, a false digital file, and you seed the pirate site yourself with a file that does not contain your entire book. And so at the end of the second chapter, it says, now you should have bought this off of Amazon.
Yeah, that's way too much work. I just let it be.
Right. That's right.
Yeah.
Video game developers do that.
Yeah, I think that's really interesting. So is there, in terms of if there is a real infringement, so there have been examples on Amazon where people have uploaded the books. I actually think Amazon now has some kind of thing in place, because you actually get an email that says, and I've had them, do you own the copyright to this book? You have to prove it. So I guess that's a sort of something that will stop that happening. But, if there is a real infringement, is that when someone would see an attorney?
Well, not just yet. I mean, there's this ladder of enforcement, I call it. And the first thing you want to do is you want to contact the person you believe is infringing you. Okay. And so you start out with the email supposing that they don't know what they've done. I mean, assume the best. Okay. And then you work up from there. So to a more aggressive email, to a takedown notice, depending on where they have the infringing work posted. And you work up from there, and then you go for the attorney and the cease and desist letter, and then potentially to litigation, depending on how much commercial impact there is. But there are a lot of things that you can do before you have to get the attorney involved.
Yeah, I think that's great. And I mean, overwhelmingly, I just want people to be less afraid of this whole area and to learn a bit more about it so that they can empower themselves in this whole domain, I guess. And you actually have a course, and you've got lots of free stuff on your site. And you've also got this great course on content protection for creative professionals. So tell people what they can expect to find in that course if they're interested.
Well, the content protection for creative professionals, I've reduced it down to a blueprint that anyone can download to take a look at what steps are involved in protecting your work so that you can profit from it. And there are a variety of things that writers and artists can do for themselves that help them improve the profitability of their portfolio. We've talked a lot today, and the goal is to create multiple revenue streams. When you create multiple revenue streams, you're thinking in the context of your overall career. So the CP2 blueprint for the course shows you what those steps are to help you create those revenue streams, protect those revenue streams, and you can choose what steps apply to your career, what works for you, and what you don't necessarily have to spend your energy on. So the blueprint is a free download. The course itself will be offered in March of 2017, and then again in the fall of 2017. The course involves live discussion with me and a lot of Q&A. A lot of information comes out when people have direct access to me. So that's why it's only offered twice a year, because of that kind of interaction. So the if you want to find out about the course, you can download the CP2 blueprint, which I think is going to be a link.
Yeah, no, you give your link.
Okay, you go to charmcitylegal.com and you can find the CP2 blueprint there at charmcitylegal.com. And so what I'm hoping to do is empower writers and artists to get a handle on this for themselves so that they don't need to come to an attorney every time they need something done. And the course will put some flesh on the bones of the blueprint to further empower and make the law accessible for creative professionals.
Fantastic. Absolutely amazing stuff. So thank you so much for your time, Kathryn. That's been brilliant.
Thank you for having me, Joanne. I look forward to coming back on some other topics.